You're watching the legal breakdown. So, Glenn, we've got our first major piece of movement in the Trump federal trial in Florida for the stolen classified documents, in that we are in the discovery phase now. Do we have any indication as to what evidence Jack Smith has?
Well, what we know based on Jack Smith's discovery letter is that Jack Smith gave Donald Trump's defense attorneys a whole bunch of evidence, recordings, audio tapes, videotapes, witness statements, and a ton of grand jury transcripts. What we don't know is what all that evidence contains, because when we write discovery letters, what we do is we generally describe for the defense what we're providing. We're providing 4 videotapes, 6 audio tapes, 11 grand jury transcripts. But what we don't do is name in that public document, the discovery letter, who the witnesses are or what they said. But Donald Trump's defense attorneys and Donald Trump himself know now who testified in the grand jury about Donald Trump and what they said regarding his criminal conduct.
Now, what can you glean from Trump's reaction to all of this?
So here's what I take away from Trump's post that seems to have been put up right after Jack Smith's team gave Trump's attorneys the discovery. Most importantly, the grand jury transcripts. You know, we often refer to Donald Trump's posts as unhinged. Well, that doesn't begin to describe what he posted after he received that discovery, because it started with, Congress, you must investigate these people. And it ended with, stop this now, exclamation point. All 82 words were all caps, right? Not a single lowercase letter in there.
Yeah.
And not only does it scream desperation, but I would call it obstruction of justice when you are urging Congress, right, a co-equal branch of government to the executive branch, to stop a criminal prosecution against you. The only thing you can call that, Brian, is obstruction of justice, though, in all candor, I don't know that Jack Smith's team will decide to indict him on yet another count, because look, at this point, he is facing more years than he can ever serve if he's convicted in the Mar-a-Lago classified documents, obstruction of justice, espionage trial. And of course, he's facing another criminal trial in New York. And we all suspect he's about to be indicted in Georgia. And let's face it, you can only confine a man for but one life. So I don't know that this will inspire the prosecutors to add charges. But boy, that truly unhinged rant tells us that Donald Trump is scared.
Just to clarify here, do you think that anything contained within Trump's all caps, desperate screed on Truth Social does anything to violate the protective order that was handed down by the federal magistrate judge?
Yeah, great question. Not yet. I would say it's kind of a violation of the protective order in the making, right? He may be getting close, but he has not outed the witnesses. He has not commented on the testimony that he saw in those grand jury transcripts. Now, do we think Donald Trump will be able to help himself and he won't stew about what he is seeing, the witnesses against him, and that he'll be able to keep from violating the protective order, saying he cannot disclose any of the information that was given to him in discovery? If I had to bet my $1, my betting limit, I would probably bet that Donald Trump will say and do things that violate the protective order. But, let me go back to these grand jury transcripts for a minute, because part of what we do know, courtesy of the indictment being unsealed in the Florida case, is that the lion's share of the witnesses against Donald Trump seem to be his own people, his lawyers, his employees, staff members. There's even a Trump family member quoted in the indictment. These are not never Trumpers. These are not angry Democrats. These are people who, in a very real sense, were on Team Trump. And Brian, if we take a quick mental trip down to Mar-a-Lago, right? I know none of us really want to go there, but if we do, and we could see what goes on in Donald Trump's office day in and day out, what he calls his 45 office. How insecure do you have to be to name your private office the 45 office after the American people fired you from the actual Oval Office?
Yeah.
Can't you almost see all of Donald Trump's lawyers and staff members and employees streaming in and out of the 45 office, telling Donald Trump precisely what they know he wants to hear? Oh, Mr. President, you did nothing wrong. Yet it's a witch hunt. It's a hoax. Everybody's out to get you. You're going to be exonerated. And I have a feeling, Brian, when all the grand jury transcripts were disclosed to Donald Trump, he probably saw those same people under oath before the grand jury talking about his criminal conduct.
Right.
And you know that had to drive Donald Trump crazy.
Yeah, I mean, we just saw an indication of that when he was asked by Bret Baier on that Fox interview, that Fox town hall, if he claims that he had hired all the best people, and yet one by one, every single one of those people who he claimed was like, his best friend, the best in the business, they all abandoned him, or he abandoned them. So, I mean, it just goes on and on. It goes to show that, even the people who were unqualified enough that Donald Trump would pick them, even those people have abandoned him. So, I mean, the list is just going to keep growing here. Glenn, I do want to know, you've drafted hundreds of discovery letters during your 30-year career. Is there anything that jumped out at you as unusual about the discovery letter that Donald Trump had?
Yeah, there was one real outlier. So without doing a sort of deep dive into the legal weeds, ordinarily, the prosecutors will give over to the defense team the grand jury transcripts only of the witnesses they intend to call at trial, because those are the only transcripts we are obligated to turn over. Because once that witness testifies, the defense attorney has every right to have that witness's prior statement, their grand jury testimony, so they can cross-examine them, trying to find inconsistencies or weak spots in their prior statement, their prior testimony. But the law does not require us to give over the transcripts of witnesses that we do not intend to call as prosecution witnesses at trial. Jack Smith's team, in authoring that letter, said, you know what? We're giving it all over to the defense, whether we're calling those witnesses or not, whether the rules, specifically, it's a law, 18 United States Code, Section 3500, the Jenks Act, whether that requires us to do this or not, we don't care. We're giving it all over. That's a show of strength. That's a show of confidence. It also helps avoid what we call the Brady problem. If there's something in one of those transcripts, now I'm doing a crim law class, if there's something in one of those transcripts that might be helpful to Donald Trump's defense and the prosecutors failed to turn it over, that could actually result in a mistrial. And think back to the Senator Ted Stevens case. That's precisely what resulted in Senator Stevens' criminal conviction being overturned, because there were some things the prosecutors didn't give to the defense attorneys representing Senator Ted Stevens. That was found to be prejudicial error. It resulted in his conviction being overturned. So Jack Smith said, I'm not playing any games. I'm not running any risks. I'm giving it all to you. That's a bold move. It's an important move. And I think it's a move that bodes well for how Jack Smith will prosecute this case moving forward.
Yeah, it's a great point. To clarify now on the Judge Cannon front, because that is still this outstanding issue that everyone's wondering about, what is the latest that the DOJ could move to have her removed or could request her recusal?
I think technically they have another few days or a week on the clock. There's a 10-day clock, although there's no really precise moment at which that 10-day clock begins to run. It's a little bit vague under the rules, but they still have some time to do it. I think by Jack Smith filing this discovery letter, I think by Judge Cannon issuing an order setting the trial date for August 14th and the motions deadline for July 24th, I think the recusal train maybe has not completely left the station, but it's pulling away. I think it's far less likely that we will see Jack Smith's team file a motion to try to disqualify or remove Aileen Cannon from presiding over the case. I still have my questions about whether that's the best decision, because I do think that Judge Aileen Cannon, given her history in the case, given her prior abuse of discretion in favor of Donald Trump, as found by the 11th Circuit Court of Appeals, I think her impartiality can reasonably be questioned, and that is the standard under the federal law that requires recusal. But it feels like people and the parties are settling in now, and maybe the prosecution has resigned itself to to the reality that Judge Aileen Cannon will likely be the presiding judge.
Yeah. Well, it seems like the silver lining here, if at least we don't see Judge Cannon recuse herself, then, we did get this show of strength by Jack Smith. And so at least that is some, a little bit of silver lining in all of this. I want to end with this, Glenn. Do we know of any efforts yet by the Trump team to delay by virtue of some lengthy pretrial motion, or are we just not there yet? Because, we've spoken about this before. Delay is exactly what Donald Trump's going to try to do. The closer he can get this thing pushed beyond the election, hopefully in 2024, the better likelihood he has of, hopefully trying to get elected president and then using the office of the presidency to basically end all of this prosecution. So he's trying to delay as much as he can. Do we have any indication yet whether he's been successful at introducing any lengthy pretrial motions?
We have not yet seen any motions filed by Donald Trump's defense team. I have a feeling we're going to hear something soon. I suspect they're going to ask for an early status hearing so they can get before the judge and they can start making their pitch to push off that August 14th trial date. Admittedly, that is a very quick trial date within about 62 or 63 days of the day he was arraigned. But as we've discussed before, the law, the Speedy Trial Act, says a defendant shall be taken to trial within 70 days of the date he's arraigned. So, it's not surprising that she set a trial date within the 70-day window, as the law basically requires. But I have a feeling very soon we're going to see Donald Trump's defense team saying, Judge, yeah, we can't possibly keep to that trial date. We're going to need more time.
And Glenn, what is that deadline for Trump's team to introduce whatever pretrial motions they're going to introduce?
So the deadline that the judge has set for pretrial motions is July 24th. I think we're going to see something filed way before that, just so the defense can try to get in front of Judge Cannon to start hashing out some of these issues, including the inevitable request for a delay.
Okay. Well, obviously, we'll keep on top of all of this. So if you're at home and you want to keep on top of legal news, make sure to subscribe. The links are right here on the screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.